Good morning. So we're having some hitches with the building elevators this morning. I guess in the grand scheme of things, that's not a bad problem to have. It could be worse. So we're here. Welcome to the First District Court of Appeals. Today is Tuesday, November 14th, and we have 3 cases on the docket today. 2 are scheduled to argue. Attorneys, when you hear your case, if you can please state your name and your readiness to proceed. So the first case we have that is set for argument is case C-230281, Raymond Cook versus Village of Laughlin.
Sean Suter on behalf of the appellant.
Good morning.
Good morning. J.P. Burley, the same firm, also on behalf of the appellant.
Okay. And I understand that you're dividing, Attorney Suter, you're going to be doing the principal argument? Okay, very good.
Attorney Susan Deaton on behalf of the
Thank you. The second case we have is case number C-230257, Sean Robertson versus L. Pamela Myers.
Good morning, Brad Gibson on behalf of the appellants.
Good morning.
Morning, Your Honor. Alan Trends on behalf of Applee.
Good morning. And the third case we have that has submitted on the briefs is case number C-230301, State of Ohio versus Rav Lowry. All right, so we're going to start off with Cook versus Village of Laughlin. If attorneys can please come forward. Attorney Suter, when you're ready, if you can come to the podium.
Yes, Your Honor, thank you.
And how much time are you going to be reserving?
Probably, what do we get, 15 minutes? Probably 10 minutes.
All right, you're going to reserve 10 minutes, or you're going to speak for 10 minutes?
I'll probably speak for 5 minutes.
Okay,
And then
all righty.
have JP do
All
it,
right.
if that's
Well,
okay.
So he's going to carry the heavy load for you?
Yes, Your Honor.
It's just a joke. You don't have to respond to it.
I will give him all the credit he deserves.
Okay. All right, whenever you're ready, you can begin.
Thank you, Your Honor. Members of the panel, my name is Sean Suter. I'm managing principal of Suter LLC. We represent the appellant in this case. This case is all about what process is due to a property owner when a local government is cutting off or desires to cut off their property rights. This is a nonconforming use case, and we appealed a decision of the Board of Zoning Appeals of the Village of Laughlin, who turned that standard of review around. They put the burden on the property owner to provide evidence of why they didn't abandon their use. But that's not the law in Ohio.
And has that been turned around all the way up to now?
Yes, because the trial court affirmed the BZA's decision. And that's not the law in Ohio, right? The law in Ohio is...
So
Yes.
the trial court did affirm, but did it say anything about the standard that the BZA used?
No, Your Honor. It said that the property owner was aware by letter from the village that the village determined that its property right had been discontinued, that it was
Well,
abandoned.
okay. So since it did not endorse the BZA's statement that Mr. Cook hadn't met his burden, does that mean that the trial court necessarily endorsed that standard?
Well, they affirmed the decision, and the decision of the BZA reads that the appellant failed to meet his burden of proof and did not overcome the testimony of the village administrator, a lifelong resident of the Village of Laughlin, that the use of the property at 336 West Wyoming Avenue for the parking of cars waiting for automobile repair had long been abandoned prior to the adoption of the RO zoning on the property.
Counsel,
appealed that.
can I stop you there?
Yes.
So I just heard in that sentence potentially 2 non-conforming uses, a car parking lot and an automobile repair shop. What is the specific non-conforming use from the use table that you contend was established by Mr. Cook?
The use that he continued to use was what we called an automobile use. Automobile use is what the term we've used to characterize it. From the use table itself, I have to look back at that. I don't recall the exact use that they used. But it was, all along, there was evidence that the nonconformity was established. There was plenty of evidence, and
So
nobody
is that,
refuted that.
is that nonconformity pertaining to any use that deals with automobiles, or is that your position?
Yes, parking of cars on the property, using the property for the parking of automobiles. And if you look back at the evidence in the record, that was established many, many, many decades ago, and it continued all the way through on this Wyoming Avenue property on the corner. Even the evidence of the village, which was flimsy at best, where these Google Earth photographs, shows that cars were being parked on the property.
So, counsel, when I look at the defined uses in the Laughlin zoning code, I do see one for a parking lot, a surface lot that provides off-street parking for motorized vehicles. Is that the use that you contend is the nonconforming use?
No, this is the use that, the two properties are owned in common, even though they're separate parcels. And so this would be a use that's associated with the vehicular repair use, which would be automobile parking associated with the vehicular repair.
So an accessory use?
Essentially, yes.
Okay, thank you.
So we get down to, how do you cut off a vested property right? Can you do that involuntarily? And the answer to that, obviously, under Ohio law is no, you cannot, right? The only way to cut off a property right involuntarily would be to take the property and pay just compensation. In this case, what we have is the court essentially saying that the vested property rights could be cut off by edict. The village says it's cut off, then they should stop, the property owner should stop using the property for that use, and the property right should be ceased.
But Mr. Suter, looking at this, I was very interested in the timeline. So the zoning regulation was in place in 2012, is that correct?
That's, yes.
Okay. According to the affidavit, I think it was Mr. Raymond?
Mr. Cook?
No. The one
Oh.
who had the business before that.
Yes.
I cannot remember his name. Reynolds? Mr. Reynolds.
That's correct.
Mr. Reynolds, according to his affidavit, had a business there from maybe it was 2013 to 2015? Is that correct?
That's my understanding, yes.
And then Mr. Cook said that he has been using that property in connection with the repair business from the day he bought it on 2015 to the present.
Correct.
Correct. Okay. So between the time the zoning regulation was passed until Mr. Reynolds started that business, what was happening at that point?
There is evidence in the record that I believe there were some tenant changes during that time, but there was not a complete intent to voluntarily abandon the property during that time. There may have been some periods of time.
How long was that time?
Where the property might have been vacant?
Yes.
I'm not exactly sure,
Okay. Thank you.
yeah. But there were periods of vacancy, and that's okay. You can let a property go vacant for periods of time. The question is, was there the manifest intent? Was there some affirmative action that said, we're abandoning this use of the property? Remember, Your Honors, that the village is telling this property owner they can't park cars on a property that's been used for cars and car parking and accessory car uses for 60, 70 years. All of a sudden, they say, we rezoned it, you can't use it anymore for car purposes.
Counsel, I'm sorry. I'm still just struggling with what you're defining this nonconforming use to be, and I want to make sure that I understand the exact nature of the property right that your client wants to protect.
The ability to park cars on that property.
And where is that defined as a use by the village of Laughlin?
Well, it was a nonconforming use that was vested. So it relates back to prior use for decades.
So what you're saying is that the conforming use list does not include that, and this and this, it makes it a non-conforming use?
Exactly.
Okay.
The
So
RO
it's-
zoning wouldn't allow it. They did rezone the property, that is correct. But the nonconforming use, the vested rights that had been in place for decades continue on unless they're voluntarily abandoned. And what evidence was brought forth by the village that there was any manifest intent to abandon the use of the property to park cars on it? There is zero evidence. And the burden was flipped to my client, the property owner, by the BZA and then upheld by the trial court. So what we're asking this court to do is just remand it back to the trial court and say, trial court, please apply the correct test in Ohio, which is there a manifest intent by the property owner to abandon. We can get back into these facts, get back into the record, but look at the record and the facts in the light of the correct legal standard rather than the standard that the village would like you to adopt, which is, a passage of time is enough. The village can send a letter saying that your property rights have been cut off. We shift the burden to you. The village did it all backwards.
I
We're
understand your
asking the
argument
court-
with regard to the shifting of the burden. I just want to make sure that that we're all on the same page.
Yes.
What was the standard of review with the BZA?
That would have been that's an interesting question. So the BZA's would have been an abuse of discretion standard. That's an administrative appeal. That is a quasi-judicial determination that they made. So that would have been abuse of discretion.
Is it an abuse of discretion, or is it a modified abuse of discretion that's specific to this situation?
You're exactly correct. That's what we would argue, yes. Because we're dealing with property rights and the cutting off
So
of
let's just
property
make sure
rights.
we're all on the same page.
I absolutely
What is
agree.
the standard of review
Standard
with
of
the
review
BZA?
should be, standard of review may be abuse of discretion, but the burden has to be properly placed. And in the BZA,
I understand that, but I want to talk
about
about standard of review, okay?
Yes, you're correct.
Because it's not really an abuse of discretion. It's actually more narrow than an abuse of
I
discretion,
agree.
is it not?
And one of the standards in an abuse of discretion would be whether the BZA acted illegally. And we believe by shifting the burden to the property owner to prove an intent to abandon, that would have been illegal.
And what is our standard of review in reviewing the BZA?
It's de novo on matters of law only. So the legal issue
Okay.
is really this burden of proof.
Is it de novo, or is it whether they acted outside of the law?
Well, I say de novo, I mean on the legal issue, whether they acted outside of the law, correct. You get to review, this court reviews the legal issue anew.
All right, thank you. You have your 5 minutes. Thank
Okay,
you.
that's all I have. Thank
All
you
right.
very much, appreciate it.
Good morning.
Good morning.
Can we start with the standard of review, please? What is the standard of review before the BZA?
For the BZA?
Yes.
Well, the question for the BZA was
No.
to determine-
Clearly, we're not the BZA. Okay.
And by the way, my name is Susan Deaton. It's wonderful to be here today. Thank you. So the BZA is tasked with determining, does Mr. Cook have a non-conforming use? That's what the question for them is based, bring in the evidence and there to look through all of the facts and make that decision. And then at the Common Pleas Court, they look at the BZA's decision to determine if it's legal, unconstitutional, unreasonable, arbitrary, unsupported by the evidence. And then this
And this is
court-
a special standard of review. This isn't like a typical standard of review that we would have for civil proceedings. Is that correct?
Correct. We don't reweigh the evidence or reconsider it in that much. We're just looking at,
Can you speak up just a little bit, please?
yes, I apologize. I've been fighting off the cold too.
Okay,
So
thank
if
you.
you need to keep reminding me that, please feel free.
And then what is our standard of review?
So this court is limited to questions of law, and so that would be a de novo to determine what the legal standards are below. So the questions now brought to this court by the appellant would be, one, what is the legal standard for terminating a non-conforming use? Is it voluntary discontinuance? Is it abandonment? Are those two the same thing? And then the secondary question is, did the trial court correctly apply that? And now there's been a lot of argument back and forth about the burden of proof, because generally while the village would have the burden of proof, to terminate a nonconforming use, you only get to that point once Mr. Cook establishes that he has a nonconforming use in the first place. And I don't think we've ever gotten to that point. So when we're asking, you know, what is the legal standard to terminate a nonconforming use, it's in the context of figuring out, does Mr. Cook have one, not in the context of, have we terminated Mr. Cook's nonconforming use? Does that make sense?
What does the village understand Mr. Cook's asserted nonconforming use to be?
Well, so our understanding is that Mr. Cook wants to park vehicles that are awaiting repair at the, so there's two properties side by side. I've been referring to them as the Anna and Wyoming property. So he's got an active car repair business in the Anna property, and he wants to park vehicles awaiting repair outside on the lot for the Wyoming property. And this is an entirely different use. The evidence below, before the BZA, seemed to suggest that maybe there was a nonconforming use at one time, but that it was like for car sales. So that's what the use was in 2012 when the zoning regulations were passed. And then it changed when Mr. Reynolds moved in and began repairing cars. And so car sales use
What use is that? I think I'm maybe struggling with terminology here, because as I understand nonconforming uses, they're defined by the municipality's zoning code. They're not just activities, you know, cake baking or something like that at a particular location. They fall into defined categories of land use, and that enables these activities as defined to perpetuate across different landowners. That's the way that we ensure legally that these uses run with the land, because they've been defined. How would the parking of cars as an accessory use to an automobile repair shop be defined by the Village of Laughlin?
And I'd have to I'd probably have to look at the zoning regulation to more fully answer that directly for you. But I think that, you know, the village has been consistent in maintaining that the use Mr. Cook wants to use it for is not the same use that it was being used before.
But, okay, let me clarify something here. So what you just said was in 2012, the use was car sales?
I believe so.
But wasn't there also evidence that in addition to sales, there were also repairs?
My understanding is there were repairs going on at the Anna property, which is a different property, that the car sales, so these properties are owned in common, but they haven't been leased and used in common. And, you know, Mr. Cook's advocated for this very broad automobile-oriented business, as though any business to do with automobiles fits the non-conforming use. But that's not the position of the village. This is a different use that Mr. Cook wants than the previous auto uses. I'm sorry, would you repeat that question? Make sure I get it right.
So in 2012, I thought there was some evidence that the Wyoming property, specifically the Wyoming property, in addition to it being used for car sales, it was also had some repair activities as well. Is that incorrect?
That was not my understanding. My understanding was that it was the car sales until, I think it was Circle's Car Sales, they moved out and Mr. Reynolds moved in. And that was after 2012, after the zoning code changed. Mr. Reynolds came in and began the car repair usage.
So are you saying that Mr. Reynolds, since it was a car repair business, that was an illegal use?
I think it would have been correct, yes.
Okay, thank you.
Was it an illegal use or was it a non-conforming use that was taking place? But because he was doing it prior to 2012, then that was fine. Did I misunderstand that?
No, I think that perhaps, you know, whatever use was in place, you know, prior to the zoning code would have been legal, but I think the change in use that occurred after that, from one type of business to another type of business, the new business, you know, didn't have the appropriate, you know, zoning certificate to do that. I think that's when it might have been broken.
So let me make sure I understand this. So what would have been the non-conforming use, which would have been legal in 2012?
I believe if there was a legal non-conforming use in 2012, it would have been for car sales,
Okay.
which is not, the village has been consistent that a car sales use is not the same as parking cars that are in disrepair, that are broken down, that don't run, that are awaiting repair for the auto body shop, or the auto repair shop.
So at one point, is the car sales non-conforming use abandoned? And by whom?
Well, so the owners of the building at this time are the Burtons, and they're leasing it out. I think when their auto sales tenant left, and they allowed Mr. Reynolds to move in with a different use, I think that was the voluntary abandonment. They're not forced to allow someone else to rent this, to change the use. I think that's the.
So it's when Reynolds takes the property?
I believe so, yes.
So Mr. Reynolds used the property for repairs, correct?
My understanding is he was in the Anna property for repairs, and the next door, the Wyoming property, was car sales. And then in 2013, when the car sales moved out, Mr. Reynolds just started using both properties altogether.
For repairs?
Yes.
And so Mr. Reynolds uses it for repairs, which you're saying is a non-conforming use, but now is not legal because the car sales have been abandoned. Does the city take any action with regard to that?
Not that I'm aware of.
Counsel, whose burden is it in the first instance to establish that a non-conforming use exists?
I believe it's Mr. Cook's burden to establish that a non-conforming use exists. And once that's established, if the village wants to extinguish it, then they bear the burden to do that.
And if I'm recalling the posture of this correctly, Mr. Cook sought two different permits. First, a zoning permit for a fence, and then secondarily, a conditional use permit once he, I think, was put on notice in some fashion that he was not going to obtain the zoning permit for the fence. Is that right?
I believe so. I think the conditional use permit was sort of for the same purpose, still to build the fence to enclose the cars.
So were those alternative, basically?
I think they were, but I could be a little confused on that aspect of it, if that makes sense.
But both
Yeah, my
permits were
understanding
seeking
is
the
that both for the
fence.
same purpose, to get the fence and to begin using it for storing vehicles awaiting repair.
All right, and so, at least with respect to the zoning permit one, it would have been his position that he didn't need to establish a nonconforming use and that he was just entitled to put up the fence and needed some kind of building permission or some such thing?
Would you rephrase that?
Did he believe he was entitled to the fence?
I think so, but
And then, at some point, he became aware he needed to show a nonconforming use?
yes. So, one, I think the underlying facts of history of this property show that Mr. Cook didn't have a non-conforming use in the first place. And then secondary to that is that Mr. Cook purchased this property. He was notified by the village right away of the restrictions on zoning and what he could use the properties for. And then, he took action on one property but not the other, and instead waited 5 years to do anything to assert, his alleged property interest. And I think that, in addition to the evidence establishing that he didn't have a nonconforming use in the first place, I think that shows that even if there was a nonconforming use at one point, he has voluntarily abandoned it.
Does
through his
it
own
matter?
negligence.
I mean, if he's using this, if the use existed, if it hadn't been abandoned, does it matter if he is continuing to use the property legally, the way that it had been used in the past? Does it matter that he didn't try to do something in 2015?
I think it does, specifically because he took those actions for the Anna property and demonstrated, his understanding.
But they're
that
separate
this is what he
they're
needed
separate
to do.
properties, correct? I mean, that's the stance that the village is taking.
They are separate.
So if they're separate properties, why would his action on one property affect his rights on another property?
And I think this is just coming down to looking at his intent and his, we're trying we've argued is the abandonment or voluntary discontinuance, but what is he doing? And I think that his actions with the Anna property, while yes, it's a different property with a different legal status, I think they reflect his own voluntary, intent to not do anything with the Wyoming property.
Counsel, he himself was using the Wyoming property between 2015 and 2020 to park cars, correct?
Yeah, that's my
And the
understanding.
village took no action to terminate that use, did it?
My understanding is he was notified multiple times during that period that that was not a permitted use, that the village had considered illegal. So if anything, he was using it under, at least the apparent impression that his use was not illegal.
But there were no citations or injunctions sought or anything to that effect?
I believe there were different zoning issues at various times, but I don't recall exactly what they were without looking at the record.
What would you ask us to point to in defining nonconforming use?
To define a non-conforming use,
What authority should we be using in figuring out what the definition of nonconforming use is?
well, I think in this case specifically, you would look at the Laughlin zoning code and what the permitted uses are to determine what's not permitted and what a non-conforming use would be.
So we would look at the
Something that's
permitted
not in the
uses.
residential office zoning.
So you're saying look at the permitted uses, and then if it's something that doesn't fall into the permitted uses, then it's a non-conforming use.
Well, do you mean like a legal non-conforming use? I don't think just because it doesn't fall in the
Well, I
zoning
asked
that it's
about
illegal.
non-conforming use. I
Okay.
started there,
Okay.
okay?
Yes.
So if that's the case, then what is faulty in appellant's position of saying, well, we're going to define it as the parking of vehicles, and the evidence establishes that that has been a continual use from the change of the zoning code up to the time at issue?
Sorry, I'm just thinking for a moment. Would you re-
What I understood is that there's a tension between the appellant and the city,
Mhm.
because the city is saying the non-conforming use was car sales.
Mhm.
And Mr. Cook, by representation, is saying the non-conforming use is the parking of vehicles.
Mhm.
Both of those, if one were to look at the code, is not contained within the code, right?
Correct.
So what would be faulty in their position of saying, from the beginning, there's been the parking of vehicles, when the zoning code changed, it was already the parking of the vehicles, up to the time at issue, there's been the
Well-
parking of vehicles, so what is at fault with that position?
I think the fault is that, we're not just talking about vehicles parking. Vehicles park on, every property, I think people come and go. A car sales use isn't just about parking vehicles on the lot, and particularly not vehicles that can't run or that are in need of repair. And so I think that's the difference there between the uses. And Mr. Cook has really advocated for a very nondescript, broad automobile-oriented use. This property has always been used for automobiles, as though any auto purpose is the same non-conforming use, and I don't think that's the case.
If this property were to transfer from Mr. Cook to someone else next year, what would be the non-conforming use that would run with the land? How would we define that?
I think it will somewhat depend on the outcome of this case, because I don't know that there is a non-conforming use for this property at this time. So I think a new owner would, again, be stuck in the residential office zoning restrictions.
And I assume, I don't have the table in front of me, but I assume that residential office has some parking restrictions and regulations that attach to it.
I believe so, yes. Yeah.
So I don't know if there's any other questions from the panel?
No.
All right, I'll give you 30 seconds to wrap up.
I have nothing further, Your Honors. Thank you
All
very
right,
much.
thank you.
Good afternoon, Your Honors.
Good afternoon.
Thank you for your very astute questions. I think you're looking at this
Well,
the
I'm
right
still,
way.
I'm going to tell you, I'm still confused on the standard of review, because I know it's quite special. And I keep
Your Honor,
hearing
I
abuse of
don't-
discretion, which is not quite special.
I think the parties are actually in agreement on that issue, Your Honor. If you look at the briefing, we did agree on the standard of review. So if, from the Common Pleas Court, from the BZA to the Common Pleas Court, the standard of review is prescribed by statute under Chapter 2506, and the Court of Appeals review of administrative appeals under that statute is de novo. You recently reaffirmed that principle in the Mount Lookout Community Council case earlier this year. So this is a legal issue. What is the test for abandonment? What is the test for terminating a non-conforming use under Ohio law? That is a legal issue that you review de novo, anew. And
Well, what about the factual findings? Because in the trial court's decision, which adopted the magistrate's decision, it found that the use had been discontinued. I can't remember exactly when it said it had been discontinued, but it found that the nonconforming use had been discontinued. So how are we to look specifically at that?
two things, Your Honor. The first thing I would say is that the application of the law to facts in the record is also a question of law that you review de novo, and we've provided support for that in our brief. Additionally, we have not asked the court specifically to get into the quote-unquote merits of this decision. We've simply asked for the court to clarify the law with respect to abandonment and to remand for the trial court to apply that law to the facts in the record.
Counsel, who has the burden in the first instance in front of the BZA to establish the existence of a nonconforming use
Your
in
Honor.
light of the fact that Mr. Cook was the one seeking these permits?
A property owner has the burden to demonstrate that a lawful non-conforming use was commenced, and Mr. Cook did do so in this instance. He provided copious evidence of the use of this property for decades prior, that the property had consistently been used for a variety of automobile-oriented businesses. You can see in the record at page 188, a report from the Department of Commerce that as early as the 1940s, there was a gas station operating here, and subsequently the site became a used car lot business from approximately the mid-1950s to present. Presently, the subject site is a blacktop lot with an active auto repair business on the southeast corner of the lot. That's from 2014.
So what is the use? And again, I'm
Yes, Your Honor.
distinguishing between use and activity, or what I'll call activity.
This is a very important question. And I understand you want to specifically define what the use is. That we would be limited by a use table if we were alleging that the use began under a prior version of the zoning code in which there was a use table. But in this instance, the use began decades ago, prior to any applicable zoning regulation. So we're not restricted by how the village defines the uses today under their current code. We're looking at what was the historical use of this property, and has that use been abandoned? And the evidence clearly establishes that it doesn't. But before...
Thank you. And can you tell me, as best you can, exactly what that use was before it was defined by the village?
So there was a gas station. There was a gas station, repair business, and sales business as early as the 1940s. Those tanks were removed. So I think the court would have no issue concluding that the gas station use was abandoned. But the repair and sales use and the accessory storage of cars in conjunction with those uses has continued consistently since then. You have on page 180 of the record an affidavit from the immediate prior occupant of the property, Mr. Larry Reynolds, in which he explained some of the prior tenants that were occupying the premises. And I believe Judge Bach was asking about this specifically. There was a business called Suhu's Car Sales, which I believe is where the car sales argument came from here. But if you look at how that was actually described, Mr. Reynolds states that Suhu's Car Sales sold vehicles, but also serviced vehicles and performed general auto repair work at the 336 West Wyoming Avenue location. And that use was there before 2012. And Mr. Cook provided his personal knowledge of the property, having been a lifelong resident. He was very familiar with how this property had been used in the past. He testified to that as well. What's notable is that the village did not present any evidence whatsoever that the use was not lawfully established. They only presented evidence of abandonment. Their entire arguments below was that the use was abandoned. And if you look at the actual language of the BZA decision, it does not say that there was no nonconforming use. It says that the nonconforming use was abandoned prior to the enactment of the RO zoning, which is 2012. So what we're drilling in on here
So
is
it sounds to me then, if we were to agree with you, that the remedy would be remand.
yes, Your Honor. I think that would be the smoothest result here.
And it would it be a remand to the Court of Common Pleas for them to re-review and then?
That's what we've
Then you would
requested, Your Honor.
anticipate a
But
remand from there.
We do need a clear articulation of the applicable test for terminating a nonconforming use under Ohio law. Other courts of appeal districts have spoken to this very clearly, and the First District has used the term abandonment in its past decisions, but it has not clearly adopted that entire test. So
Well,
that's-
okay, I'm sorry. What I'm not understanding here, though, if the use has continued, the nonconforming use has continued, it went from the Suhu property to, I think, Mr. Reynolds rented the property, and then Mr. Cook bought the property.
Yes, Your Honor.
If there was no gap larger than 1 year, do we even have to look at whether the standard for what abandonment means? I mean, I'm struggling with trying to understand what it is exactly that you are asking us to do and for what purpose.
The core issue here is that both the BZA and the trial court did not either understand or accurately apply the abandonment test. The BZA flipped it on its head, said that Mr. Cook had the burden to show that the property's use was not abandoned, and the Common Pleas Court's decision is frankly more troubling because it doesn't even use the language of abandonment. It simply states that the government provided Mr. Cook with notice, and that was sufficient. That deemed his use illegal. So we need clarity in the First District on what is the test for terminating a vested property right.
But let's go back to what I asked, though. Does it matter? If we were to find that the use had not been abandoned for 12 months or more, does it matter in this case?
If you were to find that the use had not been abandoned for 12 months or more, I think you're agreeing with our position, but I'm not exactly clear on what you're asking.
If we were to find that either the Burton's tenants or Mr. Cook, if a non-conforming use continued from before 2012, before whenever, I don't know what the effective date of the ordinance is off the top of my head.
Yes.
But if it had continued from then until the present with no more than 12 months of non-use, does it matter? Do we have to?
Is your question whether you have to remand?
Yeah.
No, I believe you could reach the merits if you wanted to, Your Honor. I believe the record is clear enough that there was not an abandonment in this case. If you wanted to put a pin in it with just one decision, I believe you could.
Well, counsel, following up on Judge Boggs' question, I mean, if we were to find that there was not evidentiary support for the BZA's determination, wouldn't that be arbitrary and capricious?
It's more than arbitrary and capricious, Your Honor. It's illegal and unconstitutional, which is also part of the standard of review. Because we have to keep in mind that these are constitutionally protected rights. In Akron v. Chapman, the Ohio Supreme Court stated very clearly that the right to continue the use of one's property that was lawfully established is within the substantive due process protections of the Ohio and United States constitutions. So it's not just that they got the evidence wrong or that they were acting irrationally. It's that they actually have violated our state and federal constitutions.
I asked your opponent, and I'll ask you, if someone else buys the property from Mr. Cook next year, what is the non-conforming use that would continue in your position?
So it would not be limited to however they would define it in the zoning code, because the use began before any of their zoning was in place. I think it would have to at least include automobile storage, which is what we're specifically asking for, but it probably also includes repair and sales, as there's evidence in the record that that use has been continuously operated at the property since before 2012 and was never abandoned.
Here's what I would like clarity on. The position that you were leading on was that the burden was shifted to your client, right?
Yes, Your Honor.
And that was the basis of the decision, and that carried over by it being continually affirmed up to this point. Okay?
Yes, Your Honor.
So it sounds to me as if the trier of fact never really got to what is the non-conforming use here.
I would agree.
We're talking about this definition of
Yes,
non-conforming use.
I would agree with.
It sounds to me as if the trier of fact never even got to that.
What's important to note, Your Honor, is that the vesting of the use was not at issue at any point. The village did not introduce any evidence to counter Mr. Cook's evidence that the use had attached. It summarily concluded in its decision that the use of the property at 336 West Wyoming Avenue for the parking of cars waiting for automobile repair had long been abandoned prior to the adoption of the RO zoning on the property. So the village really agreed with Mr. Cook at the administrative level that there was a non-conforming use at some point. The entire case was about whether it had been abandoned.
But was that non-conforming use defined? Was it defined as car stuff or car sales or
I believe
car
the term we
repair?
used at the administrative level, Your Honor, was automobile-oriented use, and it should encompass repair, sales, and storage, as there
Okay.
was clear evidence in the record that all of those integrally related uses were carried on together consistently before 2012 and after.
Okay. So if the trier of fact defined it as automobile-oriented services, okay, did the city challenge
Are
that?
you asking me that, Your Honor?
I'm hearing, first of all, did I understand you correctly? And I understood what you were saying is that the trier of fact had defined the non-conforming use as automobile-oriented services.
The trier of fact did not. That was our request to
That was your
BZA,
request.
Your Honor.
Did the trier of fact make any definition as to what that non-conforming use is, what the parameters of it is?
The closest the BZA came to articulating that, Your Honor, is in the first paragraph on the last page of their decision, in which they state that the use of the property at 336 West Wyoming Avenue for the parking of cars waiting for automobile repair had long been abandoned. That's the closest they got to defining it, but again, the attachment of the use really was not an issue, which is possibly why there's less detail than Your Honors would hope
Okay.
to see in a decision like this.
So if that's the case, then why would we go beyond the remand? We have such a limited standard of review. Are we supposed to be making decisions of, like, weighing facts and things like that?
Your Honor, I believe the law is clear enough that applying it to the undisputed facts in the record, you could resolve this case, but if the court would prefer, we would be happy with simply a remand with clarification of the law and to apply the
But how,
law
that's
to
just
the
what I'm
facts
trying to
of the record.
understand. Under our standard of review, how would we get to that point beyond remanding it?
Well, again, Your Honor,
I mean, are you saying that it's so clear, the facts, that as a matter of law, you can only come to one conclusion?
yes, that is our position, Your Honor.
Okay. That would be interesting.
So if you don't have any further questions, I'll really briefly summarize here.
Yeah, I'll give you 30 seconds to wrap up.
I appreciate your attention. Thank you. Again, this is a case not about whether the use attached. That is an argument that was entirely created on appeal. The actual decision of the BZA was that the use had been abandoned based on, I'd say, inconclusive and vague evidence at best. And the Common Pleas Court affirmed that merely on the basis that the property owner received notice of the government's position. And that's simply not sufficient in Ohio to terminate a vested property right. The government cannot take away property rights by edict. It must make the case that...
Thank you for your argument this morning. Thank you both for your arguments this morning. We will take the matter into submission and issue a timely decision. Have a
Thank you, Your
wonderful
Honor.
afternoon. Do we want to talk about enough time?
I don't give it to him afterwards. I can get it to him.
Don't even turn on. And I'm willing to take a break in that time.
Is there something with the electricity?
Maybe.
I bet
Are you sure you don't want, I mean, we can take 5 minutes.
No, I mean, it's fine.
Okay, all right.
He won't be able to repair it. I'm trying to do this.
Okay, Robertson v. Myers.
Morning, Your Honors.
Good morning.
Morning.
Good morning. Thank you for your patience this morning. I know the first argument ran a little long. You can come to the podium when you're ready.
Your Honors, Brad Gibson on behalf of the appellant, Sean Robertson. I'd like to reserve 7 minutes for rebuttal.
Yep.
May it please the court, here today on behalf of my client, Mr. Robertson, just briefly as background, this is a case that was filed simply for discovery. My client's mother passed away a couple years ago. He was a beneficiary of her estate. The main issue is that her home, which was unequivocally a trust asset, was sold just 2 months before she died. Nobody knows, my client doesn't know what happened to that money. So this case was initiated in hopes of getting the identity of the person who ended up with those funds, because we have no other way of figuring out where
So-
that money went.
Counsel, I think the skepticism here, and I don't want to put words in the trial court's mouth, but I think the skepticism is that This case might look more like a fishing expedition because of that uncertainty that you're highlighting around what happened to the funds from the sale of the house, as compared to like the example that's in the Rule 34D commentary, where there's a workplace accident or something. It's undisputed that it happened. Everybody knows it happened. And we're just trying to find out the identity of the manufacturer of a piece of equipment or something. Or another scenario that I'm familiar with is like unmasking an anonymous commentator on the internet in a defamation situation. Comment's been made, no dispute it's been made, we're just trying to find out who made it. And so can you address that kind of speculation that you're raising around, we don't really know what happened to these funds, and maybe this lawsuit looks more like you're trying to find out what happened to the money as opposed to trying to find out who the identity of some person?
Sure. A couple points on that. One, as far as a fishing expedition, the request was extraordinarily limited to the information related to one account. Two, we know that this money, the value of the house, was a trust property just 2 months before the mother passed away. The mother happened to live at my client's place in California in that time period. And Your Honor, we can get into kind of some of the comments that come out later, because I think there are other issues about the trial court's review of this case. But there were facts submitted in the record that talk about her comments that this money is in a certain account. This is trust money, was his understanding. And so that brings kind of this whole other issue of when we look at the trial court's decision here, clearly a 12B6 standard was not applied. So we would argue there are actually two bases to remand this case. One is that under 12B6, when we look at the complaint, the plaintiff, the appellant in this case, is entitled to have all of those allegations taken as true, and then all reasonable inferences therefrom. And so really the only question that was before the trial court on 12B6 was, does this complaint meet the five parameters of 34D1? So it's A through E. And we can go down each one of these and look and show that the complaint meets that standard. And
So,
that's it on
Counsel,
12B6.
your client has identified misappropriation as the claim that he wants to bring. But sitting here today, he doesn't know that misappropriation occurred, right? He thinks it might have, but he doesn't know that it has.
He certainly cannot prove that it has.
He needs this discovery to prove that it has.
He needs, I think like any case, Your Honor, you need discovery ultimately to prove beyond, to a preponderance of the evidence in front of the trial court, whether jury or judge. So I think the standard here, say, the case law would say, well, you can't go on a fishing expedition to find out if you have claims. You have to be able to articulate with some reasonable certainty what your claim is. So the claim here is misappropriation of funds that were there 2 months before his mother died.
Is there anyone he can sue today that he knows he can sue?
Your Honor, I mean, that's something that frankly was discussed before this case was filed. So the other option simply would be to sue the estate or to sue Mrs. Myers and say, well, and then go on this discovery and say, give us everything you have. And I suppose that's an option. I think the decision that was made here is to say, well, let's do this part of the civil rules that maybe isn't used that often, to say we're not trying to bring you into a lawsuit, but you have information that would say whoever it is that received this money that was there just months before she passed away.
Well, is receipt misappropriation? So well, let's make up a hypothetical. Let's say, just for the sake of, argument, that Mrs. Myers did misappropriate the money. She took it for herself and she spent it on a $200,000 car. So if we do the forensic tracing, we follow the money, we'll find that $200,000 at Lamborghini. Has Lamborghini misappropriated the $200,000?
No, Your Honor, that's a good point. I mean, it's not, it's also the identity of the account holder. So part of the claim was, in the answer, and again, we kind of get into this procedural thing, so there was an answer filed here, not just a motion to dismiss. There was a denial regarding this account, but there was some comment that it may have been held a joint right of survivorship. And so, to us, you know, could that have been a caretaker? Could there have been some undue influence? Who is this person that received the money from a home sale just before my client's mother passed away? So the identity of this account, which is all that we're seeking, or the information of this account, would identify if somebody else had the right to manipulate or move or move assets. And so that's why it was targeted just to that account. This one account that would have information of where this money from the home sale went.
Is there a set of facts where this isn't misappropriation? I mean, is there a set of facts where perhaps Mrs. Robertson herself used this money for some other purpose before her death?
Yes, I think it's possible. I think like any case, I mean, plaintiffs may come in with an idea or a belief of reasonable belief based on maybe more circumstantial evidence that things have happened, and I'm sure, as your honors have all experienced, in many cases things don't play out the way that they appeared. So yeah, I do think that's possible. And I think the purpose of Rule 34, again, is to identify an individual who may be responsible for, in this case, misappropriation or undue influence.
And you don't today know who that person is. You're wanting to find out who they are.
Yeah, and we think that the information related to this account would identify who that person is. And again, it's kind of this balancing act where I suppose a client could have just filed a suit against the estate or whatever and said, give me all the information possible. And you know, I think the thought was, well, this rule is designed to kind of prevent that. Let's not get into unnecessary broad discovery. Let's go get this one document that was requested. And again, if it had been provided, we wouldn't be here. Maybe we would be in a lawsuit, or maybe that would have ended up tracking down information that would have prevented a lawsuit from ever occurring. Sorry, Henry.
Is it undisputed that the house before it was sold was a property of the trust?
Yes.
Okay. And the account itself, if it exists, right? Well, is it undisputed that any residual in the account at the time of death is property of the trust?
I don't believe that is undisputed. So what we've heard is you're not getting this account because it wasn't trust property, which the issue with that, Your Honor, is, okay, well then would it go to probate and be distributed that way? Or is there a holder, a joint right of survivorship holder on the account? And so
I'm assuming that you're relying on the language of the trust to say whatever money that was in that account at the time of death is trust property. What are you relying on?
Yes, so a couple things. We don't know.
And we're not going to get into any I'm not even at the misappropriation of
Right.
any money before the time of death. I'm not even there yet, okay?
Right.
Are you following what I'm saying?
Yes, the trust, the way the trust was set up is that there are 3 beneficiaries, and everything save for, there were a couple things excluded from the trust, but everything was going to go to these 3 beneficiaries after, obviously, expenses and those type of things were paid. And so there apparently isn't an account that received money from the sale of a home that was trust property that somehow didn't go to the trust. We don't know. And Your Honor, you asked earlier, I mean, is it possible that there was no misappropriation? Yeah, it's possible. But I think from my client's perspective, he's sitting out, he's talking to his mother, the house sold, it netted, he believed, $200,000. 2 months later, no one knows where it is.
Well, I'm focused more on the language of the trust, because the language of the trust says, all my right, title, and interest in and to all of my property that may be legally held in a trust and that may be transferred to my trust by this assignment. And then it goes on to say the assignment includes real, personal, tangible, and intangible property located in the United States.
Right. And so, and that's what we believe, is that the money should have been put in the trust. And it either wasn't or it was spent, but this is the account that was identified. And again, maybe there's a joint right of survivorship on this account that would identify the person who we think would be responsible for this. Stepping back.
Well, before you go on, sorry.
Sure. Yes, Your Honor.
So you sued Ms. Myers individually.
Yes.
So legally, after your client's mother passed away, was Ms. Myers in charge of that account individually, or was it in her capacity as trustee or executor of the estate?
We believe she has control or possession of it as trustee or as executor of the estate. Again, without seeing it, it's somewhat impossible to know.
Okay, so
She hasn't denied having it. She's denied having the obligation to provide it to us.
did your client sue the wrong? I mean, should your client have sued her in her capacity as either trustee or executor, rather than as an individual?
Probably should have sued both of them. I mean, it should have sued her individually and as a trustee,
Okay.
to answer your question, frankly, Your Honor. But that doesn't change the fact of she's been sued for this specific information, and she hasn't denied having it. She filed a motion to dismiss. And the motion to dismiss, again, if we look at the order, there was no 12B6 standard applied. I mean, on that issue alone, I think this court is going to have to remand, because evidence was considered and the court never converted it to an MSJ, which it was required to do if it was going to consider evidence and can look at.
Is our standard of review de novo on a 12B6?
You said, yeah, so I think what we'd be looking at is independently, the court could look at the complaint and decide on a de novo basis, did it meet the notice pleading standards in Ohio? Did it meet the parts of Rule 34 in order to file this complaint?
So in some way, that standard kind of makes the trial court's purported mistakes of law evaporate because we can conduct our own review?
Yes. Yes, you can look at the complaint. If you decide the complaint meets the standards set forth and for a 12B6 motion, you can remand. And then I guess I would point out, just on the basis of the trial court's decision, one, there's nothing for this court to really rely on in applying that standard. So it's truly de novo in the sense that there's nothing really useful in there. And then secondly, noting that anything that is in there, to the extent that the court relied on it, it was improper as essentially a Rule 56 decision. But yes, Your Honors, I think as a de novo review, you take an independent look at the complaint.
And can I inquire as to how your client has been able to identify the specific account? I know there was a conversation that he had with his mother prior to her death, but how do you know the specific account that you're looking for?
Your Honor, I am not going to be able to answer that question, just from my own lack of experience with the case at the lower level. I will say my understanding through the affidavits in my review is that it was these conversations with his mother following the home sale when she did live with him prior to her death is what he brought to attorneys in my office, that information to request that account. And I believe it started, actually, he requested from Ms. Myers first on his own before we were involved.
So it's by description, not by like account number or?
It's
something?
it's by description of the account at
US
US
Bank.
Bank.
Right, okay. And I assume that's enough, well, I'll ask Ms. Myers, counsel, but I assume that's enough information for her to know what account you're talking about.
We believe so. I mean, again, there was never a response that said what account or what information. It said, well, you're not entitled to it. It's not a trust account. And
Thank you.
that answer just, it's hard to tell your client, well, I'm sorry, you don't get to find out. And again, I think that's what starts this case with the purpose of Rule 34 and say, well, let's find out where it went.
So one of the pieces of information that your client would need is like an exact account number at this point.
Yeah, and I think the way it was framed in the complaint was, well, we want a copy essentially of the statement. So just the account statement from, say, 2021 should say if the money came in from the home, where it went, who was the holder, the names that are on the account, that type of thing.
Signatories, transactions,
Exactly.
everything, okay.
All right, thank you for your argument.
Thank you.
May it please the court, my name is Alan Trenz. I represent the appellee L. Pamela Myers, who was the trustee of her sister's trust that was for the benefit of her sister's 3 children, one of whom is the appellant. Just to get you, the current status of the trust is it's over. The trust has been fully administered. Everyone's received an equal amount, and accounting was provided. We have answered all of their questions and their demands for information, except for non-trust assets. And since they raised objections almost 2 years ago, we've had no complaints about the accounting of the trust. This is all concerning a non-trust asset, which clearly a trustee of a trust has no authority, doesn't have the right to provide that information to anyone inquiring about it.
Well, counsel, as I understand the posture of this case and their request, they're asking her in her individual capacity to provide records of a somewhat vaguely described bank account that falls in your description outside of the trust. What's wrong with that? It sounds like there's a bank account that exists, and from what I'm hearing, both of you know what this bank account is, and they want it.
Well, it's all a matter of, you know, I've been doing probate work for about 40 years now. People have trusts, and they're revocable. People put assets in their trust, they take assets out of their trust, and they name people as joint owners or pay them on death beneficiaries on assets that never go into the trust. Now, Pam's duties as a trustee are just to provide information about that. And you are correct. For the first time, for all leading up to this last request, they've all been asking her questions in her capacity as trustee. This is about asking her a question in her individual capacity about something that really she has no right, no authority to provide. If we start down the road of revealing assets that a decedent gave to someone, however they gave them, it's going to open up all kinds of litigation.
That's what this action is for. I mean, the right and authority that they're seeking is through a 34D petition
Right.
for discovery. So I can understand your position that that's not just up for grabs outside of a court process. But if the court orders her to provide it, there would be a right on their part, and that's the process they're engaging. So what's wrong with the 34D process?
Well, I think you brought it up at the very beginning. Where's the claim? Mom tells me, and I'm not even saying that what he claims in his affidavit is even admissible, but he did swear out an affidavit about his understanding and she representing to him certain things. That's really on the realm of speculation. We don't really know what she said. It was
But he
just
also
one
includes the
conversation.
trust. and
Pardon me?
He also includes the trust. Are you disputing that the house was part of the trust?
No, the record shows that the house was in the trust.
Okay.
Yeah.
And he's also presenting the sale of the house.
Pardon me?
He also presented the sale of the house, did he not?
The house was sold.
Okay.
So, you know,
So if you have a trust.
whether the
I think his
pros,
position is there's a trust asset that was existing. The trust asset was sold. And then there's also a conversation about an account. And are you saying then that's just not enough?
well, yeah, because remember, as I said earlier, this is a revocable trust. She was in full control of her assets. There's nothing to indicate that she wasn't in full control of her assets. I can understand.
Doesn't that kind of go, I think, to appellant's position of like, well, we didn't file a lawsuit. We went this route because it is a revocable trust. And perhaps there is nothing to be concerned about. And
Well,
what would be wrong with one of the children pursuing to ensure that there is nothing wrong?
Well, 34D says at the beginning, a person who claims to have a potential cause of action, okay? The record, which he swore under oath in his affidavit, was that she represented to him about an account and that he understood that the account was going to be in the trust. That's all there is. And this is before her death and while the trust was still revocable. I keep emphasizing the fact that she was in full control of her assets. Many times I've had kids come in after their parents died and they said, well, mom or dad told me this or that, and it didn't happen. That happens all the time. That doesn't mean there's a claim. And as Judge pardon me?
I understand what you're saying, but isn't that something that he at least gets to look into? I mean, first of all, we have to take his statements and the affidavit as true. We have to construe them as true, correct?
You do, but it goes back to the question of hearsay, what's hearsay, and what is just
At
speculation.
this point, we have to take those as true, correct?
Correct. And you have to interpret what the words mean, too. Because he didn't say, she said this, she said that.
Well, she represented to me. I mean, that to me is she said that to me.
Okay. Well, if you look at the cases that were, and by the way, the Ahmed case, which talks about 8033 in the 8th District, if you read that case, and it was similar to a decedent making statements, but they actually said, the decedent said this. His affidavit isn't saying she said this or she said that. And Judge Dinkelacker, who was on this court when he wrote the Knowlton decision, he pointed out that 8033 can be used, but it's in situations where a person's going to testify about what a person said about the future, not the past. We don't have that in this case. We have, as Judge Dinkelacker, I think, accurately says, all we have is speculation. So, going back to my previous point about her being in control of her assets, merely because you may have heard about an asset and your parent may have said something, and again, I don't know what she may have said or didn't say, but that's not the basis, because you have to state a claim. That's not a claim. As Judge Kinsley said earlier, you look at the example in Civil Rule 34D, and you see an actual injury. In fact, if you read all of the cases that are being cited, they all have an actual injury that you can understand. Here you have, let's say, basically an unhappy beneficiary. But that doesn't mean because they're unhappy that they're entitled to have information. I mean, like I said again, this is something that happens a lot.
So you're saying that here where you have a trust asset, which is the house, and it's sold, that's the same as simply a child saying, hey, I think that my parent had this other account and that should have been part of the trust?
I'm sorry, I didn't follow that question.
Because it sounds like what you're arguing is akin to, hey, I'm a trustee beneficiary, and I believe that my parent has some other money, and it wasn't made part of the trust. It sounds like that's the scenario that you're arguing as being speculative.
Yes.
So it sounds like you're saying we shouldn't be giving any weight, any consideration, the trial court should not give any weight or consideration to that there was a trust asset, the home, and that trust asset was sold. And that the money, the proceeds of that trust asset, we don't know, the child has no idea what happened to that money. That has no
Yeah. Well,
relevance at all.
what right does the child, if you look at the cases we cited, the case of Hesselbring versus Bernard, which came out of First District, and it talks about the trust code. 5808.13G clearly that states the trustee has responsibility solely to the living settlor, and that beneficiaries do not have any right to information prior to the time that the trust became irrevocable. And it was her money. It was her asset. She can do as she pleased with it.
If she did, let's say Mrs. Robertson, prior to her death, decided to do something else with the proceeds of the house sale, would there be some documentation of that would exist that Mr. Robertson, her son, would have had access to?
Well, at this point, Your Honor, we are not going to speculate on that sort of thing. I think the point is,
Well, in due course, let's just say hypothetically, if a person removes an asset from their trust, is there a document that exists?
well, there would always be a document that exists for something like that. Sure. Yeah. But the point is, because she was in control of her assets and can do as she pleased, and no future beneficiary, contingent beneficiary, under a revocable trust has any right to information of things that happened before the trust became irrevocable. Absent, I think there's a case out there about fraud, okay? But there was actual fraud. I mean, you could prove that. It was out there. Here, there's nothing. There is just a person saying, I want to know what happened to an asset that his mother had full control of until her death. And I don't think this court wants to go down that road.
I don't think anyone disputes that the decedent had full control. I don't think anyone's disputing that it was irrevocable. The decedent in the sale of that home could have chosen to exclude those proceeds from the trust, but also could have just put it into an account without any exclusion to the trust. And isn't that the whole point of this, that we don't know how that account was set up? Whether it was set up to be excluded from the trust, or whether it was just another asset that should have been part of the trust?
Well, I guess I hate to keep repeating myself, but just because that may have happened, that doesn't give a beneficiary a right to know what happened if the parent decided to do that.
And I think that's where the contention is between you and the appellant, is whether they have the right to know.
Yeah, and I think the trust code reinforces that. And plus, you know,
Is
Judge Dingelacker.
Counsel, can we talk about this bank account? As I understand the way it's been described, Mrs. Robertson told her son it was a U.S. bank account, and that's the only information that they have at this point as to the account, and it's been described in court filings as a U.S. bank account containing the proceeds of the house sale. Is that sufficiently particular for you and Ms. Myers to understand what account they're talking about?
Well, well, number one, I hate to split hairs here, but it's been kind of assumed, and I'm not saying anything else, but just the affidavit says, shortly before my mother's death, and we don't know when and where that conversation occurred, she represented to me that she had a cash account with U.S. Bank of approximately $200,000 when discussing her assets. He doesn't say that she said that it was from the sale of the house, at least not in the affidavit. That's what's being argued. As Judge Zayas mentioned, the question is, can after a decedent's death, can the beneficiaries look back as to what happened prior to her death? Do they have any right to that? I mean, you might be.
Here's my question, counsel.
Pardon me?
Here's my question. Let's say that we were to reverse the trial court and allow this case to go forward, this petition for discovery, and they were to ask you, give us all the U.S. Bank account records. Is that sufficiently particular for you to understand and comply with what it is that they're talking about?
Well, I mean, if we are asked to provide information, I think, if I remember, the language was, they wanted information on accounts that were in the name of the decedent at her death. I don't think they focused specifically on a specific account. If the court were to order, if the trial court were to order that, my client would have to, in some fashion, respond to that and provide whatever, if there is anything, to provide subject to that order. But Judge, but you have to go back to the fact, again, I reiterate, under 34D, you have to claim to have a cause of action, and you have to describe it. You just can't speculate. And this is speculation, okay?
Isn't it always going to be a little bit speculative, though, until you have the information?
Yeah, but here's the thing. If you read the other cases.
I have read the other cases.
Yeah, and in 34D, the example, you know what the damage, you know what the injury is. There's nothing here. There's just like, I want to know what happened to this. It's like fishing expedition. That's what it is. That's all it is. And you're going to disrupt, let's say there is an account out there somewhere, and someone else's name was on it, or it was payable on death. Are you going to now get that person involved in this? I mean, it's unfair, and it goes into the privacy of whoever may have been the beneficiary of that. Why do they get sucked into this now, when she had the full right to do what she would with her assets?
I mean, I think the concern here isn't whether she changed her mind before her death. I think the concern is, what were these assets properly accounted for and distributed? Did somebody misappropriate it after she died? I don't think the issue is, okay, my mother decided to give all of her money to this nonprofit. I think it is, what happened to this, and was it improperly given to somebody?
Yeah, but do they have a right to find that out? I mean, I guess I go back to, I'm repeating myself again, but in the absence of something in the petition that really points out an injury or damage, like what appears to be the proper use of 34D, which I think is not the proper use in this case, because you're just speculating. And if you're just saying, hey, I want to, just in case, now you're kind of on a fishing expedition.
Well, I think it goes beyond just speculation. I mean, there was this house sold, where did the money go? I don't think that's just pure speculation. I think there's a little bit more to it than that, at least. I mean, wouldn't you agree that
Okay.
it's not just completely,
Okay.
reaching for straws?
But if she sold it and took the proceeds and put it elsewhere before she died, why does somebody who is a trust beneficiary have a right to know that?
Aren't you saying that there's no claim in that instance?
Yeah, just the
That
bare,
fails
the
claim
bare,
requirement?
the bare allegations is, and again, I think the example in 34D is the perfect example of why you use 34D. I was injured in an industrial accident. I got to find out who the people responsible before I file my lawsuit. Here, it's just, I got to find this out, and then I'm going to sue somebody because it wasn't in the trust? I mean, where's the claim? Where is it? Why isn't it just merely?
Well, they're trying to find out if there's a claim. They're concerned that there's a claim. And given the dynamics here and the information that Mr. Robertson had, I think we can all appreciate the situation that he's in and that he's concerned for his mother. The question is whether that concern rises to the level of 34D.
Well, I guess that's a good way of putting it. Does it rise to the level of 34D? People change their minds. They change their plan. They do things. They don't fund their trust. That happens a lot. When they were supposed to, they didn't do it. Or they took an asset that was in there and moved it out.
So let me ask this. If your opponents, if Mr. Robertson suspects that there was misappropriation or even fraud, so would the correct route be for him to sue with a fraud claim and a misappropriation claim? Is that what you're advocating here?
Earlier, I think you mentioned something about suing the estate or suing the trust. Was that your point? Mm-hmm. Yeah, that was one of my thoughts. He's not the only beneficiary of this trust. There's two others. And is the claim his? I mean, does he have a cause of action or potential cause of action? Or is it something that really belongs to the estate or to the trust as a cause of action, not him? 34D says a person who claims to have a potential cause of action. But, in these circumstances, when, first of all, we just have an alleged conversation, and they don't use words like, she said this and she said that, but, she represented to me and I understood this to be. I mean, that could be misinterpreted or interpreted any way you wish. So, and I think that's what Judge Dinkelacre, Judge Dinkelacre, he knows 803.3 rule because he mentioned it in the Knowlton case. So he reviewed it, he understood it, he saw the language, and he saw what they were claiming in an affidavit. It's not something that he can now change his testimony on. He's kind of locked into what he said. And what he said was he understood that this was going into the trust. Well, I mean, is that a hearsay exception when you not that she said it, but that he understood it? Maybe that's what he wanted to hear.
So by the very language of 34D, it permits a person who claims to have a potential cause of action to file a petition for discovery. So how would you ask us to look at that word potential in the context of potential cause of action?
Well, I
Earlier
would
you were
look at,
arguing that there wasn't in fact a cause of action. And perhaps the appellant would agree that there isn't in fact a cause of action. But perhaps they would also state, but we have a potential cause of action. So how are we to apply potential?
well, I think in the Beery case and in the Mitchell case, there was language that, if I can find it here, that made that point. Legal or unsupported conclusions, unsupported by facts, are insufficient to withstand a motion to dismiss. I think that's the standard. And I don't think the language he uses can withstand a motion to dismiss, and Judge Dinkelacker
So you want us
agree
to
with it.
apply the law that applies to a 12B6?
Pardon me?
So you want us to look at this as a 12B6, the way we would look at a 12B6, outside of the 34D? Because the 34D is giving us a lens to parse this through.
Yeah, well, I mean, I filed a 12B6 motion, so, you know,
So we shouldn't be applying 34D1?
yeah, but you still have to, as the Beery case said, as I just quoted, if I can find it again, unsupported legal conclusions
Right, but doesn't
or
that apply?
unsupported conclusions, unsupported by
Right,
facts.
but doesn't
yes.
that apply to the complaint? And that's the whole point here.
Oh,
We
yeah.
don't have a complaint.
Yeah, it's a petition. Yeah, they filed it as a complaint, but really, they changed it to a
Well, there
petition.
hasn't been a cause of action. Do we have a complaint?
No, there's not a cause of action yet, and he hasn't adequately expressed or articulated a cause of action. That's the issue here. You still have to do that, and he didn't do it.
I don't know if there's any other questions from the panel.
No.
All right, thank you.
Thank you. We ask that the court affirm the decision of Judge Dinkelacker. Thank you very much.
Thank you.
Just a couple of things in response. All this talk about the affidavits, the sufficiency of the affidavit, that would all go towards this trial court effectively turning this into a Rule 56 hearing. So I don't think any of that should be before the court. We had this discussion about, well, is it de novo review? It's de novo review if you're just looking at the complaint. When you bring in this other stuff, I think now we're saying we're doing a Rule 56 and it needs to go back to the trial court for that reason. Mr. Trent said, you know, people change their minds all the time. People lie, cheat, and steal all the time. I see it every day, unfortunately. I mean, that's kind of what we do as plaintiffs litigators. So this case is filed to get one document, one piece of information. We see there's I guess I'm a little taken aback by that, to assume that everything, the response is my client should assume that everything was above board. We should take their word for it. You got everything out of the trust.
I'm not sure that I heard him argue that. I think what I heard him argue was more so that it's an irrevocable trust, and that the decedent can do as she wishes with her assets.
Sure, that's true. She can do as she wishes with her assets, but if she's unduly influenced or if an administrator of the state misappropriates the assets, then that's a different question.
Counsel, I'm hearing a lot of ifs, and you can probably tell from my questions that I'm just struggling with what I think you would concede are kind of the speculative nature of your claims at this point and how that squares with the 34D standard. Can you
Right.
address that for me?
Yes, Judge, and I think I would go back again to something Mr. Trent said where he said, you know, you have kids come on, they say they may have heard about some account or I think my mother had that. We have a lot more than that. We have a house that's was indisputably within this trust 2 months prior to death and sold for what should have been, what we believe, without having the mortgage records or whatever, should have been $200,000 to some. 2 months prior to death. We have a trust that says everything essentially goes to these 3 kids. Everything. And we have no explanation of where this $200,000 went in the 2 months. And in that 2 months time frame, my client's mother was living part of that time with him in California, where these other statements were made and said, hey, there's this account. That's more than speculation, Your Honor. That is enough to get by, certainly a 12b6.
And your opponent has proposed kind of an injury framework for looking at 34D that, like in these other examples that we have from case law and the commentary to the rule, we know someone's been injured, we just might not know who exactly caused the injury, and 34D provides a mechanism for finding out who caused it. Can you address this case through that framework?
Yeah, I think so there was a trust asset, this home, or call it $200,000, that my client as a 1/3 beneficiary would have been entitled to, I don't like doing math, $60-some thousand, right? He didn't get it, so he was injured. I think now we need to find out who injured it. And they're going to turn around and say, well, it wasn't a trust asset in the 6 weeks or so leading up to your mother's death, but we're not going to tell you why. We're not going to tell you what happened to it, and you don't get to look at it. You don't have a right to look at it. And you're going to say, what, the trust law beneficiary right? Well, we have a right to look at it because we filed a lawsuit and we alleged facts per Rule 34 that would have a court to allow a court to say, okay, give them this document. And it goes back to, he doth protest too much. Why? It's one account that they refuse to provide the information for, which could have settled this a year ago.
And on the particularity piece, so one of the requirements of 34D is that you describe the information you're seeking with reasonable particularity. Do you feel that you've done that, and if so, why?
We feel that we've done that because our understanding is there was a U.S. bank account that Ms. Robertson had that was not seen in the trust assets, that the documentation of how things were distributed. They also, we think, because we asked for it, and they didn't say it didn't exist, they just said, you don't get it. So, yeah, I think Mr. Trent's answers were pretty telling that they know what we're asking for. They have it, they don't want to give it to us. So if that's the answer, that we don't have it, then that should have been the answer to the complaint. We ask for things in discovery all the time, and parties come back and say, we don't have it. And then maybe there's a follow-up that has to occur from that. But we believe it was sufficiently specific enough for them to produce. I think that shifts the burden on them to say, we don't know what you're talking about, or we don't have this. That's not what we've heard. We think, again, Your Honor, there's some discussion about the claim. The case law says that you have to allege sufficient facts to show that there may be a potential claim, as Your Honors pointed out. And then it also says, the fact that the requested discovery may lead to the discovery of other claims, that's not a reason to justify dismissing or denying the petition. So, are we able to articulate what exact claim it is going to be right now? No. But what is the basis of the claim? The claim is trust assets, my clients and beneficiaries entitled to 1/3 of them, and they disappeared. Misappropriation, undue influence, those types of things arise from there. And I think on the complaints, when you take the allegations as true, along with the reasonable inferences, I think clearly a claim has been asserted, or a potential claim has been asserted. And again, I would just reiterate, on a 12B6, each of the 34D1 factors were pled in the complaint. There's no basis for dismissal. And then, again, if we do get into these affidavits and other things, then I think we're outside what the proper review for this court would be, and we would have to kick back anyway. Unless there are any other questions, Your Honors, I would say we ask that you reverse the trial court's decision. And thank you for your time.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Give me a moment, Renata. Give me a moment. Give me a moment before you. All right.
Court of Appeals, First District of Ohio is now adjourned.
Thank you, Renata. Have a great day.